Hello, everyone. A very warm welcome. I'm delighted to see so many of you here today for our webinar. It's the first of our webinars in 2022, and I'm sure that 2022 is going to be a very interesting and thought-provoking year for everyone who works in or around public procurement law. So some quick introductions. I'm Jenny Beresford-Jones. I'm a professional support lawyer and public procurement specialist here at Mills and Reeve. And I'm here today with my colleagues, Shailee Howard and Helen Prandy, both of whom are principal associates here and also public procurement specialists. So that's the panel here today. I can see we've got many of you in the audience. A very warm welcome to everyone. It's great to see all of you. Before we do get started, a couple of points of housekeeping. So if there's any technical issues, hopefully you'll all be able to get connected okay, but if they're having any difficulties, please just pop a question in the Q&A box, and my colleague Claire, who always does a really good job for us of managing the technical side at these events, she will do her best to help you get connected. Also, if you have any sort of legal questions for the panel, do feel free to put those in the Q&A box as well. Unfortunately, we can't take questions during the webinar itself due to the constraints of time, but we'll try to come back to as many of you as we can after the session, probably via a Q&A document, which will circulate. Just to note that nobody will see your questions other than the panel. So we would encourage you to consider leaving the remain anonymous box unchecked, because if we know who you are, it will allow us to come back to you on your question if we need to. So the questions are not visible to everybody in the webinar. I should mention to you, the session's being recorded, and we'll circulate a copy to everybody afterwards, a copy of the recording, and also that only the panel speakers can be seen or heard on the recording. And finally, assuming that the technology works, and hopefully that it will, at the end of the webinar, you should see a very short feedback form pop up. And if you're able to complete that, that would be really great. We really value feedback, and it will help us make sure that our future events are interesting and relevant. And we're planning several more webinars, particularly those in our 5 in 25 series that we began doing in autumn 2021. Those are going to continue this year, so do look out for invitations to those events if that's of interest. So I think that was all I was going to say on housekeeping. So perhaps to make a start on the webinar itself. So what we're looking at today is the government's recent response to its Green Paper consultation on the reform of public procurement law. And before we actually get into that, we thought we'd start with just a reminder of how did we get here. So it all kicked off in December 2020, when the government published its Green Paper, setting out what I think it's fair to say was a reasonably radical vision for reforming procurement law that perhaps went further than we might have been expecting in terms of the range of the proposals. In January 2021, the Brexit transition period ended, and of course the relevance of that was that the EU directives on public procurement ceased to apply, and that of course allowed scope for reform, opened the door to reform. The consultation closed in March 2021, and then in December 2021, just in time for us all to read it over the Christmas holidays, or not, as the case may be, the response was published by the government, and it's that response that we are looking at today. One of the key things of great interest in the response was the timeline for all this change, and I think everybody is very interested to know when we might expect to see a change. So the key takeaway is that we are still expecting it to be at least later in 2023 before the new regime actually goes live. And as you can see from the steps on that slide that we need to achieve to get there, there is quite a bit of work for government and for everybody involved in public procurement to do to prepare for what will be quite a significant change. So in the rest of the session today, we're going to take each of the 8 chapters of the response and just sketch out for you the key changes that we can expect to see in the new regime. And it is worth pointing out that certainly on current plans, at least, there are not going to be any further consultations. So the position in the response that we're outlining today does represent the policies and approaches that the government is intending to legislate on. And it's just worth noting too that we produced a briefing paper that goes into more detail on each of the chapters, and that will also come around to everybody after this event in our follow-up email. So do keep a lookout for that, because I think it would be useful for everyone to refer to if you want to get a feel for the changes that are coming down the line. So I think that was all I needed to say in terms of an introduction. So I'm going to hand over to my colleague Shailee, who's going to look at the first chapter for us, and that's around procurement that better meets the UK's needs. Thanks, Shailee.
Thanks, Jenny. Hello, everyone. So I'm going to talk to you about Chapter 1. So firstly, we have these expanded principles of public procurement that will be enshrined in the new law. They're there on the slide for you to read. You'll see some of them look quite familiar. So transparency and non-discrimination, we're quite used to those. Others are new, for example, ensuring value for money and maintaining integrity. And while the words might be new, the concepts certainly aren't. So, for example, integrity is defined in the Green Paper as good management, prevention of misconduct, and control in order to prevent fraud and corruption. And there's always been an obligation on authorities to take measures to prevent fraud and corruption. You might also notice that the concept of proportionality has disappeared, but that's not to say that the obligation has completely gone. The Cabinet Office has said that authorities will still need to think about proportionality at the appropriate juncture, and that will be made clear in the new legislation. So, for example, the new law will say that timescales must continue to be proportionate to the requirement. The response to the Green Paper says that fair treatment of suppliers will cover equal treatment of suppliers as well as procedural fairness. And so that means that authorities will still need to ensure that there is a level playing field. And in addition to these 6 principles of procurement, there are other concepts that have been set out in the Green Paper, which will be established as statutory objectives that authorities will need to have regard to when they are making decisions through the procurement process. So, for example, another of these additional objectives is around the importance of open and fair competition. I think it will be interesting to see exactly what that means. So we don't know whether it will include sort of competition in the more legal sense, so focusing on things like anti-collusion and cartels, or whether it will have a wider meaning of ensuring open markets that are accessible to different kinds of suppliers. I think it's fair to say that I think there's some nervousness amongst authorities around how they can clearly demonstrate that their processes comply with both the principles and the statutory objectives, and how they avoid legal challenge. And the Cabinet Office has said that it will be clear what the requirement is to satisfy the principles and objectives. It might be the first of many times that I say this, but I think that the devil will be in the detail. If we can move on to the next slide, please. You may have also noticed that one of the principles on the previous slide is working towards the public good, and this is to encourage authorities to think more widely around delivery of strategic national priorities. The National Procurement Policy Statement is designed to articulate what those matters of national strategic importance are, and the Cabinet Office has already addressed this element. So the NPPS was published in June of last year in PPN 05 and applies until the end of the current Parliament. And at that point, it can be reviewed again and potentially amended. and the current NPPS covers social value, commercial and procurement delivery, and skills and capability for procurement. So you can look that up and read that at your leisure. I'm going to pass to Helen now, who's going to talk about the third element of Chapter 1.
Thanks, Shailee. Good morning, everyone. Yes, it seemed logical to ask a disputes lawyer to just talk briefly about this, although we'll come on much later in today's session to talk generally about the reform that the government's proposing to disputes. It is planning to create something called the Procurement Review Unit, indeed beyond planning, because they're currently advertising certainly on LinkedIn and online for a head of that service. So if anyone's interested in applying for that job, they might want to look for that one. But it's important to emphasize that whatever the Procurement Review Unit does, it's not going to be there to satisfy individual complaints about individual procurements. It's there to ensure that authorities behave systematically in accordance with the regulations and rules. And it won't be there available for an individual to come along and say, such and such an authority has breached the rules, what are you going to do about it? It's proposed to legislate to give the Procurement Review Unit, which will sit within Cabinet Office, powers, and that will enable it to issue directions to authorities, particularly in the case of systematic breaches. But as Shailee said, and which you will hear us say probably a number of times this morning, the devil is in the detail around that. There doesn't seem to be much there at the moment. It is also worth noting that something called the Public Procurement Review Service already exists. For those who might remember back in the day, this was called the Secret Shopper Service. And as a disputes lawyer in procurement, I've never actually come across anybody who's tried to refer something to the Public Procurement Review Service. It is, I think, not very highly manned, so there aren't a huge number of civil servants dedicated to dealing with it. And we will have to see, obviously, whether the Procurement Review Unit, how fully staffed that is, what powers it has, and therefore how interactive it is with procurement under these new proposals. Thank you.
Thanks, Helen. So that was Chapter 1. I'm going to go on and just very briefly look at Chapter 2, which is where the response sets out the ideas about what the government is planning to do in terms of the design and structure of the new procurement regime. So in terms of the sort of bare bones of the legislation, as it were. So as most of you will know, at the moment, we've got 4 sets of regulations, at least, dealing with public procurement expressly. The Public Contracts Regs 2015 is, of course, the main ones, but we've also got the concession contract regulations, the utilities contracts regulations, as well as the defence and security public contracts regulations. And in addition to those, there are also various other pieces of legislation, such as the Public Services Social Value Act, which also really impact upon procurement. So as we sort of tried to show on the slide, the idea is that all of this sort of various diverse sets of regulations will be replaced by one unifying set of rules, which nonetheless will contain sector-specific sections or will be tailored so that it can work for various sector-specific scenarios. And that is to address concerns raised in the consultation that if all the rules are unified into one, some of the derogations which are currently enjoyed by certain sectors might be lost. So if you're a utility authority, you'll be pleased to know that certain sector-specific exemptions will continue. So utilities will be exempt from the procurement regime if they are already directly exposed to competition. Current flexibilities around qualification systems and frameworks will continue. Also, in terms of concessions, there will be, in this single set of rules, concession-specific details around how you calculate the value and duration of a concession. There will be various defence-specific elements. I won't home in on those, that's quite specialist. And also the light touch regime. So many of you will know that currently under the public contracts regulations, certain types of services, health and social care services, are subject to a higher threshold under the public contracts regs than ordinary services. And even if that threshold is breached, there are more flexibilities to design a procurement process. When the Green Paper was initially published, there was a proposal to just get rid of the light touch regime altogether, on the grounds that the new procurement processes, which I think Shailee will talk about next, were going to become so much more flexible that there wasn't really a need for a light touch process. But following feedback, there was strong feelings that it needed to be retained. And so it is going to be retained in a developed form. And particularly those health and social services where service user choice is important, so perhaps choice of a care home will be made exempt from the full force of the regulations. Of course, it remains to be seen exactly how that will work in practice. Also keep in mind that in relation to clinical health services, such as hospital community health services for the purposes of the NHS, these will be within the remit of the new Health and Care Act, which is due to come into force later this year, and regulations will be introduced under that act, which will remove those sorts of NHS clinical health services from the remit of the procurement rules altogether. So it looks like the light touch regime will remain, but it will be in a sort of slimmed down form. So I suppose the overall takeaway is that, of course, I think a simplified single regime sounds like welcome news. Only having one set of regulations to refer to be great for all of us procurement lawyers. I suppose there is a question around, given how many sector-specific features have to be included, whether these regulations might not end up being very lengthy and perhaps not quite as simple as we might have initially hope. But then it does remain to be seen, as Helen and Shailee have said. So that was chapter 2, and I think that takes us on to thinking about procurement procedures. I think, Shailee, do you want to pick that one up?
Yes, thank you. So chapter 3, as you'll see on the slide, the government is going to reduce the number of available procedures down to 3. I think it's fair to say that flexibility is the theme of this chapter. The response to the consultation says there was some nervousness around the introduction of the competitive flexible procedure. I think the risk is that with flexibility comes the risk of reinventing the wheel with each procurement, which increases cost and complexity, not only for authorities, but also for suppliers. And I think this is an opportunity for the legislation to sort of empower authorities to benefit from the flexibilities afforded by the reduction in the number of procedures. So I don't think the legislation should necessarily prevent an authority from using a restricted style process if that's what's appropriate for that particular contract. And as ever with public procurement law, I think transparency is really important, and the new legislation will allow authorities to design their process to fit the requirements. And I think for this chapter, this is something that permeates the response, but guidance and training will be particularly key here to avoid authorities sort of reverting to type and failing to make the most of the benefits of the relaxation in the rules. If we can move on to the next slide, please. You will have noticed there was a reference to limited tender. So this is designed to cover circumstances such as extreme urgency. The government is going to proceed with this, and the current provisions around extreme urgency and unforeseeable events will be retained. The response says that the government is still considering the best way of effecting those changes. So it's considering introducing a statutory instrument where action is necessary to protect life. And the response acknowledges that this would only ever be used extremely rarely, particularly as we now have the limited tendering ground available. This is quite timely, given publication of the judgment yesterday on use of Regulation 32(2)(c) that you may have seen reported in the press. And I guess it's fair to say that there's still a requirement to publish a transparency notice when you are relying on this ground to allow scrutiny by all interested parties. The response doesn't make any other mention of the other Regulation 32 scenarios. So, for example, the single supplier exemption. So it remains to be seen how that is addressed. And as Jenny has just said, the light touch regime will continue, but with some slight changes. So I think that brings us on to Chapter 4, awarding to the right supplier. And this really covers the substance of the procurement process. So firstly, the government is implementing the change from MEET, most economically advantageous tender, to MAT, most advantageous tender. And the change might seem subtle, but it's designed to allow authorities to take a broader view of evaluation criteria to apply in their procurements. So, for example, social value. And as I mentioned earlier, there will continue to be a requirement to ensure that the award criteria applied are proportionate. It will also remain necessary to ensure there is a link to the subject matter of the contract. And that's the case, for example, under the social value model, under the current regime. Although, as it says on the slide, it is possible to include other criteria in key policy areas. The response doesn't give much detail on this, but says that the government is considering the ability to make secondary legislation to reflect policy priorities, which I imagine may be linked to the NPPS that I mentioned earlier, and things like net zero. Again, I think this is an area where authorities will benefit from some clear guidance in order to remove the risk of legal challenge. The guidance should clearly set out the situations when it might be appropriate to move away from the subject matter of the contract. And as ever with procurement law, I think this is an area where the audit trail becomes important. So authorities will need to make sure that their decision-making processes address the reasons why the authority considers it appropriate to take other policy considerations into account when scoring tenders. The new legislation will also allow evaluation from entities other than the authority procuring the contract, for example, service users. I think this is a really welcome provision and will hopefully lead to better procurement outcomes. However, I think it's important that the legislation or the guidance is clear on how authorities may select who evaluates responses and the obligations of the evaluators in order to reduce the risk of legal challenge. I'm thinking about things like conflicts of interest. So moving on, so the new legislation will also update the mandatory and discretionary grounds for exclusion that suppliers will need to look at to demonstrate that they can continue participation in the procurement. Both the mandatory and the discretionary grounds will apply for 5 years, and the legislation will clarify when that 5-year period begins in each of those cases. For discretionary ground, it's when the authority knew or ought to have known of the existence of that ground, which I think could potentially be quite tricky to articulate. There are a couple of key changes. Firstly, it will be a mandatory ground if a supply doesn't disclose its beneficial owners, and a deferred prosecution agreement won't in and of itself constitute a discretionary ground, but may suggest the existence of a discretionary ground for exclusion. It will still be possible to self-clean, as in the current regime, and there's a reference to the ability to continue in the procurement by showing evidence that a supplier remains reliable despite existence of one of those grounds. One of the key changes proposed was the introduction of a centrally managed debarment list. This is something that already exists in some European countries. And the response to the Green Paper shows that there was broad support for this proposal, but the government does not intend to immediately legislate on this. There is a proposal that a minister may direct a supplier to be added to the debarment list where it has been excluded on a mandatory ground, and where a discretionary ground applies, addition to the list will likewise be discretionary. The newly created procurement review unit will have responsibility for considering those cases and considering whether a supplier has sufficiently self-cleansed in order to come off the list, and suppliers will also have the right to appeal to court. I think this is likely to be a part of the Green Paper that follows, as there are clear questions around its operation. So, for example, whether the list will be public, what measures can be put in place to ensure consistency, and it seems there will be an awful lot of work in maintaining it and getting it right. I'm going to talk a bit about past performance. So there is already a discretionary ground for exclusion based on poor past performance, but it is limited to where a contract has been terminated early or there has been a payment for damages. And that means the reality is it's not used very often. And the proposal that will be taken forward is that this ground is expanded to also include a situation where a supplier has failed to remedy a breach following the authority having exercised a contractual right to require it to do so. So as I say, it's a widening of the ground, and because poor performance is rarely dealt with via termination or a court order, but rather contractually between the parties, and I think these latter measures now come within the scope of this ground. I think this is another area where proportionality will be really important. Authorities will need to be confident that they are exercising their discretion correctly in order to avoid legal challenge. There is intention to create and publish a contract performance register to hold data on supplier performance against KPIs. So it's not clear whether the new law or guidance will address the issue of how serious the conduct or breach has to be in order to trigger the ground. Responses to the consultation noted some concerns that in some cases poor performance can be quite a nuanced area. It could be due to reasons outside of the supplier's control, or for example where the supplier has taken on a particularly risky contract because there was no opportunity to negotiate the terms and conditions, and for example in those scenarios it might be that exclusion is unfair. There are also questions around how the contract performance register will be administered and which contracts will come within its scope. Another system, so there's also an intention to create a supplier registration system, which is a single point sort of electronic data storage system owned by the Cabinet Office. And I sort of understood this to be a bit like the ESPD that existed sort of pre-Brexit. So suppliers will register on the system and be responsible for the accuracy of the data that they input. And when a supplier enters a competition, their self-declaration, for example, that none of the exclusion grounds apply, will be submitted to the authority via that system. So I think all in all, a good idea aimed to sort of simplify the process, but potentially questions around whether there will be scope for the system to cover more bespoke selection information. Authorities will also need to be clear what information is obtained from the system and whether they might want to accept alternatives or require additional information. So I think this part of the proposal will need to work well with the selection sort of phase of the process. Jenny, I think I'm handing over to you.
Yeah, thanks, Shailee. So this chapter 5, is really looking at using the best commercial tools, and it's focusing on two things really. One, developing dynamic purchasing systems, and two, developing framework agreements. So on this slide, we're looking at what the proposals are around dynamic purchasing systems. So at present, you can only use dynamic purchasing systems, or DPSs as we all know them, for the more sort of common commodity type contracts. And they involve quite a bit of work on the part of the authority that is setting them up and running them. but it's not possible to charge participants any kind of fee for the privilege of being on the system. That's the position as it currently is. The response is intending to sort of really develop DPSs into something called a dynamic market. The finer details on how this will work are not yet available, but the idea is that the dynamic market is going to be suitable for a much wider range of goods and services, able to procure much more complex requirements. It's still the case that contract notices will still be needed every time you want to procure a contract under the DPS. So I think some people might say that keeps some of the current disadvantage of the DPSs in place, but the government has countered that by saying that these sort of administrative burdens should be made easier by the changes to using data systems and electronic notices and so on, which we're coming to talk about a bit later. Utilities will still, following responses to the consultation, be pleased to see that they have the right to continue to use qualification systems as at present. And another new feature of the response, it is going to be possible, subject to certain limits and the need for fees to be put back into the public sector, it is going to be possible for the authority that owns the dynamic market system and runs it to charge a fee to those contractors who are successful in obtaining a contract from it. So that's a change from the current position. And also, at the moment, I think there's no central register of DPSs available. And I think in the response, it sort of came up that there were real difficulties with suppliers knowing where they should register, having to register multiple places for the same system. So there's a sense that all that could be sort of rationalised and all the opportunities put into a central register to help suppliers know where they should be registering their interest. Similarly, on frameworks, there is intention to really develop those into sort of next generation, if you like, frameworks 2.0. At the moment, as I think we probably all know, a framework agreement has a limited duration of up to 4 years, unless there are exceptional circumstances, and those situations would be, I think, probably vanishingly rare. And also frameworks, once established and set up with the panel of suppliers, new suppliers can't be added to that framework arrangement. So that means that it's a sort of fixed snapshot as at the date that the framework is entered into. And as with DPSs, there's no opportunity for contractors to be charged any kind of fee to cover the authority's costs in maintaining and running the framework. So the new sort of landscape for framework, as it were, it's got some quite significant changes. So the 4-year closed frameworks will continue as currently, but the new proposal is that there will be a new 8-year framework, which is going to be open to new entrants as long as an initial period of time has elapsed since it was set up. So as you can see, that brings into a framework some of the dynamic advantages of a DPS, the idea that the framework can develop dynamically with the market. And potentially it could be a really useful tool because it might combine the advantages of frameworks and DPSs. So a dynamic adaptation to the market, but also with fewer tenders to evaluate because there's still a limited number of suppliers on the panel. And as with DPSs, there is a proposal for a central register to make it easier for suppliers to find opportunities, and also that if a supplier is successful in obtaining contract of a framework, there may be a possibility to charge that supplier subject to the limits that I mentioned earlier. So I think as with everything, the devil's in the detail. It really does remain to be seen exactly how the dynamic market will work. but there is an intention for quite comprehensive guidance, templates, and so on. So once we get those, I think we'll have a better idea of how these commercial purchasing tools will work in practice. I think that was all I had on chapter 5. So chapter 6 is on transparent and open contracting, and that's Shailee's going to talk about.
That's right. Thanks, Jenny. So again, as I said earlier, one of the themes running through the Green Paper is embedding transparency throughout the procurement process, even more so than it exists already. The government is planning to introduce most of the proposals that it set out in the Green Paper, although has dropped the proposal to require submitted tenders to be published. And I think that's a good outcome, given the potential risks around disclosure of sensitive information and impacts on re-procurement exercises. You'll see on the slide the current planned list of notices that will be required to be published, and these will be required for above threshold contracts. Some notices have higher thresholds attached to them. So, for example, a planning and pipeline notice and notice of planned procurement is required for contracts valued over 2 million. I assume that's for goods and services, as works contracts will have a higher threshold, but I think that could be clarified. The range of notices required has been expanded and will inevitably require consideration and resourcing by authorities. And I think further guidance will be welcome on the content of each of these notices. And authorities will also need to make sure that their e-tendering portals are ready to effect the changes to the number and the format of the notices in good time. The government is also going to implement the open contracting data standard. And what that is it enables disclosure of data and documents at all stages of the procurement process, and it defines sort of a common data model. And the idea behind this is that it allows better analysis and potentially monitoring by organisations such as the Procurement Review Unit and potentially other authorities as well, like the CMA. The government is in the process of creating a central platform that promises to make it very easy for authorities to publish the right data in the right space. Adoption of the ODCS will be mandatory, so like I say, that data across the public sector can be shared and analysed. Authorities will need to conduct some due diligence to assess any interoperability issues, and again, I think e-tendering portals will also need to be ready for this change. So on the next slide, just a quick word on the requirement to disclose redacted contract documents. There will be a threshold of £2 million attached to this obligation, but the government has said that this may be lowered in the future. Concerns around redaction will be addressed through guidance, and I think it's hoped that this would be largely uncontroversial given the current obligation to publish contract documents on Contracts Finder, and you'll find details of that in PPN 921. I think Helen's going to talk to the next 2 points on the slide.
Yes, thank you, Shailee. The principle of transparency is obviously extremely important, and currently transparency about outcomes of procurements, the reasons why you scored what you scored, and where the winning bidder scored better and why is currently set out in what used to be called the Alcatel letter and is now the award notice or the debrief letter. It's now proposed that debrief letters won't contain that type of information. We don't know exactly what information it will be in, but they won't exist in the form that we currently know them. And instead, what's being proposed is the disclosure of evaluation documents. Now, any of you who've been involved in a procurement challenge might know that it's not you're not obliged at the moment to disclose evaluation documents, but you are, by the guidance of the Technology and Construction Court, suggested that you should do so. And clearly, if there's nothing to hide in the evaluation documents, then it makes good sense to produce them. and hopefully to get rid of any challenge that there might be at an early stage. So the kernel of the suggestion here comes from that principle of procurement litigation around the existing guidance about disclosing evaluation documents. The difficulty here that I foresee is it's absolutely fine to send the evaluation of the tenderer's own bid out to them, and that's proposed to be done. Where I think there are going to be real difficulties is the extent of redaction of the evaluation of a winning bid, because often in the evaluation of a winning bid, if it's meaningful, there might be some reference to a particular commercial advantage that's being suggested by that winning bidder, and which they wouldn't want drawn to the attention of their competitors. But who decides how that's redacted? In theory, it should be for the winning bidder to identify what is commercially sensitive and ought to be redacted. But here at the moment, the proposal is that the authority should make that decision. And I think that leads to potentially very difficult areas of dispute about whether something was disclosed but should have been redacted, or the other way around. So I think it's important to see exactly how that's proposed to work in due course. The other thing, obviously, that it highlights, and which is something we stress anyway to clients over and over again, that you need to make your evaluation material bomb-proof. It needs to clearly set out what the reasons are for the scores awarded and why. And if it's going to be seen, if you know it's going to be seen, no more hostages to fortune. And we still occasionally see in evaluation documents now things like definitely not as good as the winning bid, or didn't offer this and the other person did, or I don't like bidder X because they really annoyed me on my previous contract. So even more emphasis is going to have to go into making sure that evaluators do their job properly and clearly and fairly record what their evaluation reasons are, so that they can go into the disclosure. And talking of disclosure leads us on to chapter 7, fair and fast challenges. Now, with all things in the consultation, this started as a very noble intention of making it quicker and easier for people who have a legitimate complaint about a procurement to bring it. And there were proposals that, for example, the contracting authority might themselves have an independent review body which could review complaints, or to bring it more in line with the practice in parts of Europe, to set up a specific tribunal that would be able to deal with complaints, particularly lower value complaints, without the need for a bidder to go to court to assert their rights. Unfortunately, none of that has survived the consultation process. And the government is still now intending that any challenge to a procurement is going to have to go through the High Court of England and Wales, which of course makes it almost prohibitively expensive for some SMEs, for example. Litigation is not cheap. With the best will in the world, it's also not particularly quick. And unfortunately, the Ministry of Justice has been one of the departments which in the last few years has suffered very badly with austerity cuts. So it is currently under-resourced. And its response to that has generally been to put up court fees, which of course creates an even bigger hurdle then for people wanting to enforce their rights. So this really is a case where we're going to have to look to the detail of how the government proposes to do this through amendment to the CPR, which are the civil procedure rules, and through guidance from the Technology and Construction Court. Guidance, of course, is just guidance. It's not mandatory. So any significant rule change would have to occur through the procurement, through the civil procedure rules themselves. We'll have to wait to see what becomes of that one, but it is a little disappointing that an opportunity has been missed to enable some particularly lower value procurement claims to be challenged more readily by smaller bidders, to the point where at present their access to justice is probably restricted by the need to go to the High Court. And then in terms of what happens when you get there, well, in the consultation, there were a number of proposals about putting caps on damages, either before or after or during the procurement. None of that survived, but instead, what is proposed is a new test for lifting or maintaining the automatic suspension. And just quickly, the automatic suspension is something that occurs automatically as soon as proceedings are issued by a disappointed bidder, and it prevents you from proceeding with the procurement. So you are unable to award the contract until you've dealt with the matters related to the automatic suspension or having it lifted. Now, this was introduced into English law in the regulation, the amendments in 2006. And it was known initially as a reverse injunction. And the way that, therefore, that the court decided to look at how it would consider claims of lifting the automatic suspension was that it would adopt the rules of law that was set down in a case called American Cyanamid for the imposition of an injunction. The government proposals are to do away with the American Cyanamid test and to instead to make something that's more procurement specific. Unfortunately, though, they haven't said what that would be. And American Cyanamid has stood the test of time with the English courts and actually sets out some pretty clear principles, which often boil down to where the balance of convenience between the two litigants lies. And it's difficult to see how a new single limb test will actually be very different from that balance of convenience test. So again, the devil will be in the detail on this one, but it's difficult. It almost looks like reinventing the wheel. And probably what we'll end up with is something very similar to what we currently have. What is new, though, is the power to suspend automatic suspension, in a manner of speaking, in times of crisis or urgency. And the government, I think, saw quite a lot of this during the pandemic, where it wanted to make urgent decisions, but was constrained by the difficulties it faced with the threat of a challenge, which would then suspend the proceedings. So I think that does make sense. But again, we'll have to see on what basis that's available.
Helen. So if an authority has managed to avoid a challenge and has awarded a contract, procurement law will continue to apply, as is the case under the current regime. A couple of elements to this chapter. So firstly, suppliers will be able to approach authorities directly to escalate any payment delays, provided they can show that they have taken reasonable steps to obtain payment. And authorities will also be empowered to look at supplier payment performance down the supply chain during the procurement. And there will be a unified reporting system for both authorities and suppliers. If you have a spare 5 minutes, you will see that most of the work that the current Public Procurement Review Service does is around ensuring prompt payment. So the PPRS publishes quarterly reports on its work. It remains to be seen how enforcement of these rights and obligations around prompt payment will fit within the newly structured procurement review unit and the PPRS. And the government has said they will provide some clarity on this. Finally, a note from me is on modifications to contracts. So this will largely remain as under the 2015 regulations, with the definition of substantial modification being made more clear, which I think most procurement lawyers will celebrate and welcome that clarification. A new safe harbour will be introduced, permitting the amendment of complex contracts, and also the current extreme urgency safe harbour will be amplified in order to maximise flexibility in the crisis. So the experiences of the pandemic very much fresh in the minds of the government here. If we just move on to the next slide, I wanted to flag the new requirement to publish a contract amendment notice in all of those cases when the contract is being modified, except when it is low value or a short-term change. And we assume that the legislation will mandate a time period within which the notice must be published. Under the current rules, there are in some circumstances the obligation to publish a modification notice, but there's no time limit attached to that obligation. Another new provision is the introduction of a standstill period before the amendment is entered into. This is a lot more like the award of a contract and is designed to allow interested third parties to understand the nature of the amendment and challenge it if necessary. Once the standstill period is over, the ability to challenge the amendment is likely to be limited. The only exception to the obligation to have a standstill period is where the contract is being amended owing to crisis or emergency, but the authority will still need to publish that contract amendment notice. So I think that's all from me, Jenny.
Thank you, Shailee. So yes, I think that wraps us up for today. A few minutes early, so everyone get a few minutes of their day that they weren't expecting to have, which is always welcome. Please do look out for our follow-up email. So we should see in that there'll be a recording of today's session. There'll be a copy of the slides, a copy of our detailed briefing note, and also our Q&A response document where we come back to you on the questions that you've asked us. And just a reminder that when the webinar ends, you should see a feedback form pop up. And again, we're really grateful if you would just take a minute or two to fill that in. And so just thank you very much to everyone for attending. Really hope you found it useful. And do look out for an invitation to our next webinar, which will be part of our 5 in 25 series of webinars that we are running throughout 2022 on all sorts of interesting topics to do with public procurement law. But yes, thank you very much everyone for attending, and hope to see you all again soon.